if any of you are doing working with lawyers who are doing bail for the first time or rather raw about the whole issue, do let them have a copy of these slides as well, particularly these links, which are essential. The How to Get Out of Detention handbook from BID is a basic handbook that is absolutely, we've tried to make it as simple as possible for everyone who's not a lawyer to understand, but we expect all our volunteer lawyers to have read it and to know it. And we actually ask our clients as well, those who are English speaking, to also read it. It's available in some translated in some languages. So do go to our website or via the link that you'll find here. The first tier tribunal's guidance to first tier judges is essential because it includes a lot of principles about bail and detention. And then there's the Home Office guidance, there's interim guidance, which also includes some information about accommodation issues. There's a general policy called Detention General Instructions, which in particular focuses on people who've completed criminal sentences and are facing deportation and when they should be detained. And then for you who might work with people in prisons or people who've completed sentences, there's Home Office policies generally about offender management, and there's a prison service instruction, which, as with all prison service instructions, they might say that the document expires valid until date, but unless there's been a policy issue that overturns it, that policy remains relevant. And then we've got a link here about other documents that are available through BID's website to do with deportation in particular, and there was a talk about it recently. This slide refers to some of the basic rules for you to be aware of, and it's always good for people trying to work on the law to understand what's allowed to go to the basics. The detention centre rules includes Rule 35. We might mention that again later on. The short-term holding facility rules has, minimum periods of detention. The prison rules are applicable to everyone, but people who are serving time, who have served time in prison, has completed their sentences, they're to be treated like remand prisoners, so who are normally pending prosecution. So those are the main documents that might be of relevance to you. A lot of these may become somewhat supplanted by the illegal migration bill, partly because that bill will introduce the authority of the Secretary of State to detain people anywhere she wishes. And that has implications for rules that regulate detention. A basic starting point for people who don't know about challenging detention is that there's no right of appeal. There is no formal complaint system about detention, although you can complain to the Home Office basically about anything really, but you can also complain to the institutions where people might be detained about treatment. The absence of any automatic judicial oversight of detention means that there's really two ways of challenging detention. One, the government is claiming through the illegal migration bill at the moment, habeas corpus. It claims it's a fantastic solution, but actually habeas corpus allows detention. So the government's been saying the illegal migration bill that habeas corpus is going to be available still for people because it's doing some dramatic changes and trying to get rid of judicial review. Habeas corpus is a way of challenging an unlawful detention because there is no power in law to detain. Judicial review is the power to challenge the way the law is being applied. So yes, you're allowed to detain, but you're now detaining unlawfully. And the big case is Hardil Singh. And Harjil Singh, which is dating back from 1984, it talks about the minimum requirements for detention to be lawful. And I've listed them there, but to summarize, basically, is it's got to be for a reasonable period and for the purpose of removal. If someone can't be removed, then you have a problem. And I will mention how the illegal migration bill effectively does two things. One, it changes the way that judicial review is to be interpreted, so that the Secretary of State has the sole power, really, in deciding whether or not something is lawful. And it would be very difficult to go to the admin court, even where it's arguable that her decision has been a big mistake and is an error. It's only going to be in circumstances such as bad faith. And two, it prevents an application for judicial review within the first 28 days of a person's detention, in addition to removing the right to apply for bail within the first 28 days. So what's going on there is that what will happen is that detention will be used not for the purpose of removal. And the Secretary of State will say the opposite, but making it impossible for her to be challenged, I think answers the question. If you're going to make it easy for yourself to make poor decisions, you're going to change the way detention is being used. And of course, the rhetoric is all about using the law or introducing measures to deter people. And I think that probably says enough. The 2016 Act introduced something called Schedule 10, which basically is the place which summarizes all the different laws that are to do with bail in particular. And I'm only saying that I'm going to skip over that very quickly, and will explain that anyone can be detained. If you arrive in the UK and you're going to be examined about your identity, you can be detained. But again, Harjil Singh principles apply for a reasonable period, and the Secretary of State needs to act expeditiously. Also for the purpose of removal or deportation, so it needs to be possible. You can apply for bail to the Home Office at any time, and before 2016, people would be granted temporary admission by the Secretary of State. That all changed, and it has various implications. I don't think I'll go into that now, about how things change in terms of decision making. Suffice to say that one consequence of that is that temporary admission was often obtained by means of correspondence by lawyers with the Home Office. Now the Home Office will say, no, you need to make your application by way of a bail application. And then when it refuses bail, it often does it in a very short letter without addressing the issues that the lawyer has raised. And that really means you need a good lawyer who's awake to the issue about not accepting a decision from the Home Office, which is really poor. And then there's the tribunal. You can apply for bail to the tribunal as long as you've been present in the UK, whether you've arrived by boat and 8 days later, or you arrived years ago, you've been present in the UK for more than 8 days. You can apply to the tribunal. We at BID will always and nearly only apply for bail to the tribunal, because it's in the independent court. It's a bit weird applying for bail to the Home Office that has made the decision to detain you. And it's very difficult to succeed with a Home Office application. But if your arguments have been dealt with in the tribunal and you get refused by the tribunal, there might be purpose also to get a response, to get some information from the Home Office. There might be a purpose to submit an application to the Home Office. Be aware also, as soon as you get detained, people, including people in prisons, they should be given an information pack that will include these forms, the B1 form and the Bail 409 application forms. Be also aware that when someone ends their prison sentence in particular, opinions are meant to have been formed and release plans formulated by the probation service. And they are meant to be in a position to be advising the Home Office about risk levels and about release and availability of accommodation. All these factors are meant to have been concluded at the start of a person's immigration detention in a prison. Of course, it doesn't always happen. When someone is released, this lists the conditions of bail that can apply to them. Only one condition has to apply, okay? So you can just be released to no address and be asked to report, or vice versa. There is a basic issue everyone needs to understand, is that you do not need a surety, or what is now called a financial condition supporter, because a lot of lawyers do advise clients that their case is not ready because they need a financial condition supporter. It might be that a legal aid lawyer says you need one because I think that your case is so weak that for it to have merit and for me to grant legal aid, I want you to have a financial condition supporter. But even if a legal aid lawyer advises that, they should be advising people that they can make their own applications. You're not going to grant legal aid. That doesn't mean that you leave people waiting to make an application. With electronic monitoring, we are here, it refers to a catch-22 issue for people to consider. On the one hand, arguing that you're okay with an electronic monitoring condition may allow you to argue that an eye can be kept on you constantly, and therefore the risk of absconding is much less. But of course, it's completely intrusive, and it's not just intrusive because of bail, but it's also intrusive because Home Office policy allows information from electronic tags to be checked in relation to other matters, such as an Article 8 claim. You know, has a person been meeting or taking their child to school in the mornings? Has a person been breaching their conditions by going into an area or near the family home where they're prohibited from going? Those sorts of issues may be taken into account. Nevertheless, anyone who's committed an offence will be monitored. So unless there's human rights reasons why they shouldn't be, and that would involve an issue such as mental distress, someone who's psychologically ill, who's had a similar bad experience of wearing a tag, etc. So an application can be made for that not to be applied, but judges have no power not to issue a tag where someone is facing deportation after having completed a criminal sentence. The conditions of bail that apply when you're going to be released, I know this, I'm repeating myself again, sorry, I went backwards rather than forwards. So this is what I've just explained about the financial condition. And so, you know, only treat it as an additional factor to a condition that you're willing to apply. Some judges are going to find it favourable, others not, but never accept advice or anyone saying that you shouldn't apply for bail without a financial condition supporter. There are basic issues that Schedule 10 requires judges and the Home Office to consider, and they're listed here. And anyone preparing a bail application needs to be aware of these issues and needs to address these issues in a bail application. And with people who've committed offences before, there's obviously a big issue that at the bottom of this list, you'll see that the 22 Borders Act introduced any non-compliance with the immigration process as a negative factor to be considered. I think you need to bear in mind also the illegal migration, well, both that act, that act also increases the punishments for illegal entry to 1 year, and illegal entry includes being in the UK waters and not just arriving at the UK shores. And of course, the way that the current bill that's going through Parliament is framed, everyone who's arriving by boat is going to be arriving unlawfully, is going to be susceptible to a criminal charge or offence. Whether or not they'll bother instituting those offences, we don't really know. There's going to be so much litigation on that point, especially as a lot of people arriving and who will be subject to all these punishments are going to be recognised refugees, or are going to be refugees who should be recognised as such. To give you a bit of a sideways comment on it all, is that if everyone's being excluded from this process, with the Home Office refusing to consider asylum, I would look at getting UNHCR to recognise me as a refugee, as a protective factor. These are some of the arguments the Home Office says and responses. So just put them in here just for you to consider. And there are, some of it is obvious, but it's making sure that you deal with the issues. If the Home Office says that someone is a serious risk of offending, well, do they mean that they arrived without any documents and applied for asylum because they got a one year sentence? Because a 1 year sentence is a serious crime now that leads to a deportation order. So you need to really look at the offence, and you need to also look at an OASIS report, which is issued to people if they've been sentenced to more than a year. So that's a probation officer's assessment of a person's risk of reoffending combined with their risk of harm. And I'm going to skip these because I think I'm going to deal with them now in a different way. So if you're going to, one of the major issues to argue in a bail application is that detention is no longer justified. We say no longer justified. In the High Court, we say is no longer lawful. We say no longer justified because there's going to be delays. Removal is not imminent because of these sorts of factors. And these sorts of factors listed here are legal barriers, but also practical barriers. On the practical side, actually, what I should have included as a link is something called I think if you Google travel document guide, you will come up with the Home Office. It's a country documentation guide, which lists timescales and requirements for obtaining documents for each country, and bids in the process also with a few appeals going forward where we're trying to get disclosure from the Home Office of the numbers of documents disclosed for certain countries to support our bail applications effectively. The Home Office is arguing that it should not disclose these documents because of its relations to countries, and we say that the right to liberty trumps that. The national referral mechanism is here, main issues are listed here. So if you make an application that you've been trafficked, there's a procedure to recognise whether or not there's reasonable grounds, and then there's a decision as to whether or not there are conclusive grounds that you have been trafficked. There are consequences in terms of the Home Office's inability to remove someone for at least 30 days. And there's consequences also in terms of the support arrangements that they should give. And someone who is going to be tagged may have difficulty getting any support from the Salvation Army, who are one of the first responders, the organisations that can act on behalf of people who've been trafficked, but also who are meant to provide accommodation support. unless you can show that you are in danger, in continuing danger from your traffickers in the UK, then the Salvation Army may become involved in sourcing a safe house for you. But at the bottom, we've put in, watch out for the disqualification letter. That is a letter that says that you're a threat to the public order. And that, I think, includes someone who's been sentenced to a year or more, or you've claimed to be a victim of trafficking in bad faith. And this is the kind of letter that people are now starting to get, which you might have seen. And it says where the disqualification applies, the following cease to apply. Okay, and so all the protections basically cease to apply. This is becoming subject to a lot of litigation, and the I think Duncan Lewis solicitors are doing one on the whole policy. I think Wilson solicitors have got a number of judicial reviews on this issue. Another issue that you're wanting to argue in a bail case is to argue that you're unlikely to abscond. And so here are some issues that you can consider. Your immigration history, whether or not you've previously reported. If you've previously not reported, i.e. in Home Office language, absconded, you need to explain what that was, why it was. And very often people say, well, I called up the centre and I told them that I couldn't come in, and they told me come back in next week. I went back in next week and I reported as normal. Yeah, it still comes up on the computer as that's absconding. So then that goes into a Home Office document arguing that you've previously absconded and shouldn't be released this time round. Other incentives not to abscond are ongoing matters that you've got in your case, wanting access to family and children, needing access to medication, the fact that you have a surety, significance is misspelt there, typo, and then accommodation, showing that you've got a stable address is very important. And you can look at these sorts of phrasings, go to the guidance for bail judges, do Control F, and look at where the guidance deals with these issues, and then quote the guidance at judges and at the Home Office even as well. The Home Office won't like having to be guided by immigration judge guidance, but if they are going to have the power to grant bail, then they should do it as well as possible. Then low risk of harm is what you're wanting to argue wherever possible. But even where someone is a serious risk of harm or of reoffending, if they're not going to be removable, our argument will always be release someone while they are still under license. Because while they're under license, they have the protection of the probation service monitoring them. They are being engaged with. They are being assisted through engagement with integrating into communities. And even if they're facing removal, until they can be removed, the public abroad, as much as the public in the UK, should be allowed to benefit from these sorts of protections. The risk, of course, if someone's license expires while they're still in detention, they're still not removed, and then they're released without any supervision from the probation service. So license restrictions, you need to get a copy of the license to which former prisoners are entitled. These detail what controls the probation service requires upon the person's release from their criminal sentence. And that can be additional, or will be additional, to immigration restrictions or requirements. And you need to make sure, a lawyer needs to make sure that an immigration restriction does not contradict a restriction put into place by the probation service. And remember, one of the biggest protections is that if you're released under license, if you commit an offence, then you are put back into prison to complete your sentence automatically. And the level, the breaches of licenses, you know, they're not that you have to commit an offence, just breach your license, not present yourself to the probation service when you're meant to, is a breach of a license that can lead to months, years back in prison. You want to get information about a person's conduct in detention, which will help, especially if the Home Office is attacking them. And as we've said before earlier on about monitoring, electronic monitoring is also another protective issue. But one of the things that you need to also understand is that the Home Office will say person's a serious risk. Probation Service identifies risk of harm and categorizes that, and risk of reoffending and categorizes that as well. And they're quite distinct issues. You know, someone who's committed murder is actually often a very low risk of reoffending, while someone who's done petty shoplifting to feed a drug habit might be a low risk of harm, but a high risk of reoffending. So you need to, you know, judges need and people need to understand what these mean, rather than just saying serious risk of harm. The Home Office's guidance, detention general instructions, does define for itself that where it sort of has a table where it says if one is higher than the other, then the overall risk is the higher one. But you know, when risk is examined, I always say, ask the Home Office more and more about how it has reached its conclusion on risk. Of course, sometimes just the original sentence is a sufficient indicator, depending on the nature of the crime, of risk. And so your focus then goes on to managing risk and behaviour in prison, any good behaviour, any courses attended, those sorts of issues are very relevant. Then you'll also be looking at whether or not your client is an adult at risk in detention. And there is a Home Office policy, which I can't believe I'm not given the link to that. But there's a Home Office policy that defines it. And it's summarized very simply here. And you know, a lot of this is being contradicted by the illegal migration bill, because of course the illegal migration bill is going to allow detention and no challenges for the first 28 days. So even when you argue that someone will be harmed in detention, and where you might argue that these levels of evidence apply, then you will still have a big difficulty in trying to make a judicial review challenge. But the different levels here relate to the sorts of approaches of the Home Office deal with interpreting whether or not detention continues to be suitable. So self-declaration by a person is a low level, in a way. Level 2, a professional evidence makes them potential adult at risk, is a higher level. And then level 3 is basically a statement by professionals saying that detention will cause further harm to the person. And detention's only allowed, justified under Home Office policy, where removal is imminent or the person presents a public health, public protection concern. You've got here indicators of risk, and I'll just say that, you know, there are first responders. We write, the Home Office is a first responder, so we refer to the Home Office agency that deals with trafficking to refer people who may be trafficked. And there are indicators that are listed here, but often someone who has worked in a, let's say in a cannabis farm, low level sort of crime, may have done so at the instigation of someone else, or may have done so to pay off a debt. You start looking at at violence being threatened, or at slavery being effectively used by them having to pay off a debt indefinitely. There's also, if I got next, yeah, Rule 35 reports, special illnesses. Rule 35 is where, and Rule 34 reports, Rule 35 is where someone claims to be at risk of torture, or there may be health issues such as suicidal ideation. And what should happen in those circumstances is that a person should be examined by a medical practitioner and a report prepared about them. Interestingly, we challenged the Home Office recently by the fact that we were told by clients that reports would take, that people were taking 1 month to be seen by a doctor at Harmondsworth in order for a report to be drafted. And we wrote saying, at the time of the suicide there, we said, how can you have such delays? You need to prioritize these, because if you're reviewing detention, then you could be preventing suicides or other risks of harm to people by ensuring that these reports are produced at an early point. Home Office replied and said there's no requirement in the rules for us to make a decision on a report, to consider a report, or prepare a report, I should say, within any time period, which obviously is inadequate. Now, whether or not we would take that forward as a challenge, I think we're probably going to need a case to tag it to, for us to show that that is systemically unfair and unlawful. The law says, and again, the illegal migration bill contradicts, but the law says that the Secretary of State must consider the best interest of the child. And while up until now, the detention of a child is restricted to a limited period, children who are alone can only be detained for up to 24 hours while care arrangements are put into place. Children with families can only be detained for about 1 week. So that means that children can't be detained. However, there are also children who are impacted by the fact that their parents are in detention. And so getting details about the children, the extent to which they have contact with the children, is absolutely essential. And arguing that, nearly always the Secretary of State fails to consider the best interests of the child and leaves the obligation upon the person to put forward arguments in that regard, even though they are meant to, the Secretary of State is meant to consider these issues herself. Of course, there's going to be a massive contradiction between this and the illegal migration bill, which will allow the detention of children who are alone and children with families. How they're going, the other thing that's being abolished by the new bill is the family returns panel, which is a panel that's made up of non-Home Office staff as well as Home Office people, but health or social services professionals as well, who are responsible for caring for children. And they're meant to look at the impact and removal arrangements, the impact of these upon children. That's being abolished, and there's been no explanation of how that is going to be replaced, or how, therefore, any of these issues sit alongside this best interests issue. And the other point to note, I think, here is that not everyone who is detained under this is going to be actually removed, we suspect. And so the impact upon a child of arrest and detention and their subsequent release will be looking really closely. We need to look closely at what support arrangements are going to be put into place for these children to come to terms with what has happened to them. I had one child, well, 3 children who were detained in a single cell many years ago when detention of children was allowed for 3 weeks with their mother. And afterwards, the eldest child was receiving regular weekly counselling at school because he kept on drawing pictures of himself shooting immigration officers with a machine gun. And we've just had, completely out of the blue last week, another child producing a picture of himself doing the same thing with prison guards. And the picture has his mum in a cell. So that gives an indication of the sorts of things we're going to be looking at, having to deal with the new bill. Then, of course, bail guidance looks at the length of detention and interprets it in these ways. Now, I have to say that 3 months, 6 months are quite unusual. In our organisation, we have a lot of people who are detained for that length of time because they often are in prisons, they lack access to lawyers, lawyers refuse to grant legal aid to them. And so we will come, you know, we sort of like, we take on the cases where legal aid is not taking up representation. I think the difference with the legal migration bill will be that the majority of people who are released within 1 month will almost certainly be detained as soon as there's detention capacity. So the world will change, and we'll see how this bail guidance will change, if at all, as a consequence of it, particularly when the first month is not going to be considered a lengthy period because there won't be any challenges on that basis, you know, because how bad length of detention is will depend upon the facts of each case. Someone who's mentally unwell is arguably, you know, detention might be unlawful for 1 hour. Someone who's not removable, when you know they're not removable, at the point when you're deciding whether or not to detain them, should not be detained for a minute. That's all Harjil Singh principles, you know, and the ability to challenge on those bases is going. So there's, let me carry on actually. Decision to grant bail, very simply put here, all arrangements need to be put into place and with a grant of bail. And you need to be, let me go back if I can. You need to be aware with the legal migration bill and with accommodation centres, which are becoming quasi-detention, is whether or not whether or not a person is actually on bail, or are they being detained? If they're on bail, they should have a grant of bail form. Have they got a grant of bail form issued either by the tribunal or by the Secretary of State? What does that actually say? People in hotels or accommodation centres are told you're not allowed out. Is there a condition that on my bail grant that says I'm not allowed out? Am I allowed to apply for the variation of that condition if there is such a condition? How is that condition justified? Are subsequent things that you'd be looking at after bail has been granted. The other thing is, be aware with tagging that that sometimes release on bail can be delayed for 3 days, 72 hours to enable a tag to be fitted. I mean, it's quite ridiculous, really, because all places of detention should have tags available, we say, because they only take 15 minutes to be fitted. But anyway, 72 hours is found to be a reasonable period. And a grant of bail form should therefore, you know, it should be argued in a court that please put on the grant of bail form that the person should be released if after 72 hours a tag has not been fitted, and invariably the form will say that the tag can be fitted at the person's place of accommodation. There's a consent rule which says the court is not allowed to grant bail if the person is going to be removed within 14 days. That has been replaced, well, that is going to be sidelined a bit by the legal migration bill, which will allow someone to be detained and not to be granted bail for 28 days. Nevertheless, this is quite important. And when the Home Office argues that we intend to remove them in 14 days, you need to know the date. And some removal directions, people are issued with removal directions, and they will say a date to be notified. Well, that's not within 14 days. So you should apply for bail, and the first tier tribunal can grant bail. And the power to vary bail conditions, that is when you apply for bail on the bail form for the tribunal, one of the questions people are asked are you happy for management of bail to be given to the Home Office? The normal practice of the tribunal before the changes under Schedule 10, before these new bail forms were introduced, and that question was put, was that whenever the tribunal would grant bail, it would pass management of bail to the Home Office. But bearing in mind that this form and the law and the change in the law says that bail, management of bail can go to the Home Office, being asked, are there any reasons why it shouldn't be, can be a useful issue. We do a standard paragraph that says, I want to see what conditions of bail, or the Home Office bail summary, its reasons for opposing bail, which is issued 24 hours before the bail hearing. I want to see what that says first before I decide on my position. And there are certain circumstances where you might oppose it. And that circumstance would be, for example, a condition on residence. And where the Home Office is due to give accommodation. If the Home Office is to give accommodation, you want the tribunal to retain control and management of bail in order to ask itself whether or not the Home Office is acting expeditiously, and whether or not it will be questioning Home Office behaviour to the extent of whether the bail conditions should be changed and someone should be released to either an alternative private address, or would it be easy to the streets? I don't think so, but we can discuss that separately as well. So if management of bail does go to the Home Office, once it goes there, the tribunal loses control. There are legal arguments where it might be possible to make a challenge arguing that is not the case, but that, and one or two lawyers I know, Simon Cox at Doughty Street, has been thinking this, but there are possibilities that a challenge could be made in the future. But in the meantime, when management of bail goes to the Home Office should not reverse the conditions or change the conditions. It needs to have good reason to do so. We're referring cases for judicial review challenge because someone's bail conditions have changed. They've had reporting restrictions imposed that are much harsher than what the judge imposed. So be aware that the Home Office can only do something like that, or even go against its own policies, unless it's got very good, sound reasons for doing so, and it needs to explain itself well. And having argued a case in court with a bail case, it's on a loser generally when it does this. Bail accommodation, I will try and finish fairly quickly. I am getting nearer. The bail accommodation is the bane of a lot of people's lives because a large amount of people are granted bail but stay in detention. And BID has just made submissions to the European Court of Human Rights that argues that detention is used in the UK for the purpose of accommodation and not just for the purpose of removal. And this is why. It's because bail is granted to people, and then there are steps to take for applying for accommodation and delays sourcing accommodation by the Home Office. Now, if you're a refused asylum seeker, or if you're pending, you've applied for asylum at some point, then you have to use an ASF1 form. And what we really say with any application for support is submit the application at the point when you're applying for bail. That's because you're unlikely to get a decision on your application before your bail application is decided. So if you get bail granted, you can argue with the judge, I don't have an address, but I've lodged an application for accommodation, which should be pending. If you're granted bail, you then send the evidence of the grant of bail to migrant help, who are the conduit of all Home Office support applications. And this is also to avoid the Home Office making a decision on an application for accommodation where if you haven't been granted bail, it will say you're being accommodated adequately in detention, which I think speaks for itself as to the purpose of accommodation in this context. That anyone who's not an asylum seeker, not previously been refused asylum, can apply for Schedule 10 accommodation, paragraph 9, which the policy to which, the Home Office policy, which is to be found in the bail policy, says the application can be made in the person's grounds for bail. But actually you can also now, before you couldn't, you can also make it on form 409, Home Office form 409, you need to. And the Home Office policy really focused on people being high risk, being granted this sort of accommodation. It was a bit mad really, because on the one hand, if you're really high risk, you'd probably be given approved premises accommodation by the prison service. But if you're not sufficiently high risk, you have to prove that you're still of sufficiently high risk for the Home Office to give you accommodation. But those arguments have been lost by the Home Office because their policy also talks about someone suffering inhuman, degrading treatment if they're not accommodated. Destitution is just that. There's also bail in principle is when it is actually something that was dealt with by old bail guidance that dated back to 2012. It talked about bail in principle. The new bail guidance for judges doesn't mention bail in principle. It was issued in 2018 after Schedule 10. That's because what the now former president who issued that guidance, he said to me was, there's no such thing as bail in principle. There's only a grant of bail and a refusal of bail. And I think that that is something that we need to bear in mind, that even where someone's not got accommodation, we ask for a grant of bail with a residence condition. You get that. You can also say we want management of bail to be retained by the tribunal so that it reviews the issue of accommodation. Okay, but what we're trying to avoid by saying that in that way is I'm trying to get judges to accept that the decision by a previous judge to grant bail was just that. And their role is not to review whether or not bail should have been granted, it's to review the bail condition itself, and that's it. So it's a bit of a fine point, but I think it's quite an important one. And then the 28-day period between bail applications, which means that, you know, before you could apply for bail as often as you wanted. And so you would even apply for bail knowing that you might get a liberal judge. So even if you've got a couple of sentences in your bail application, you attract the Home Office bail summary and you get a chance at bail. You fail with the bail summary from the Home Office, you know what their reasoning is, and you prepare your grounds for bail. That is quite difficult to do now. And so increasingly, you need to make sure that you've got a well-prepared case. Sorry, go back to it. So increasingly, you need to ensure you have a well-prepared case. And so the issue, you know, because 28 days delay is quite a long time. But let's say you got refused bail. I say a surety might be what makes a difference for you to apply for bail more quickly, or a change of surety, or emphasis in the bail grounds on a change of a condition or a change of an address, because the previous address may have been found to have been unsuitable. That's the change of circumstances, which I think would be adequate. There we are. Any questions? I think I've zoomed through, not given too much time, I'm afraid. I'm sorry about that. But you've had a big sweeping review of detention. I can see a couple of questions. Maimuna, I can't hear you. I don't know if you're there, or shall I just look at the questions I can see?
Yes, so there's 2 questions. Can you hear me?
Yes.
Yeah.
Yes.
The first one, I don't know if you want to take this one first, is this only applicable to solicitors a certain level of OS registered, and if so, which?
Yeah. Okay. So level 3 allows for applications to go to the for people to make applications before the tribunal. Level 2, people can make bail applications to the Home Office. Unfortunately, all this area is regulated work, but hopefully from what you've seen on here, at least being aware of what people need, and what to expect from lawyers in particular who are representing is really important to know, because I think it's a murky world, and so just being ready for that is really important to support people, and it helps us as well, knowing that people are aware of what a bail summary is. Makes a big difference, because when we ask for it, knowing that bail refusals are issued in writing is important, or that person may have been granted bail and should have a bail form outlining conditions of bail. That's important. So all these things, being familiar with these things is quite useful. I think the main focus is representing someone is not allowed unless you're regulated, and advising someone on steps they can take is not allowed. But informing someone of what the law says, as long as it's not couched as advice, may be allowed. I think I'd put it like that. I hope that helps.
Yeah.
Yeah.
Thank you, and I hope that answered your question. The second question was, what if you want to ask for a reconsideration for a negative decision and the first responder was the Home Office? How do you ask for the details from a Home Office first responder when the decision is negative?
When the decision is issued, it will include information about how to respond. Yeah, so you can ask for a review. The Home Office should review. Does that? I think otherwise, the main thing with all engagement with the Home Office is, even where there's not an appeal, what you always want to do is attract the decision, a response. So if you're saying, but if I'm going to review that, if I'm going to ask them for a review, and it's the decision makers or the authority that refuse me that's going to be reviewing it, they're obviously going to refuse again. Yes, but as long as your reasons are good, then their reasoning is going to have to be better. If not, they'll be opening themselves up for a legal challenge. Yeah.
Thanks, Pierre. Were there any other questions? Those were the only ones that were submitted. But if anyone has any last minute questions or comments, feel free to pop them in the chat now.
Yeah, let me have a look in the chat in case anyone's said anything. No, that looks okay. So I hope I haven't overwhelmed everyone. Don't, it might have been quite high level at times. You might feel a bit overwhelmed, but hopefully you'll also find the slides, etc., informative. If you need information about an issue that a lawyer is advising someone on, you can take a look at the slides, and hopefully they'll answer some questions. and good luck for anyone
Yeah.
helping people.
And if anyone wants to contact you, is there a way they can do that?
Yeah, they can contact me either by emailing me direct at pierre@biduk.org, or if they have a case for referral, they can contact casework@biduk.org. Okay.
Thanks so much. And we'll share that in the email with everyone that attended today, with the slides and with any other useful links that were talked about today. Lots of thank yous for you in the chat, Pierre. So thanks everyone and have a lovely evening.
Great, thank you. Cheers.